Um, Good evening, everyone. Today we are discussing about the specific types of torts. There are four types of specific torts: nuisance, defamation, trespass, and negligence. Um, first we are discussing nuisance. Nuisance is derived from the French word "nuire," which means to do hurt or to annoy. According to Salmon, the wrong of nuisance consists in causing or allowing without lawful justification the escape of any deleterious things from his land or from elsewhere into land in possession of the plaintiff. Example: water, smoke, fumes, gas, noise, heat, vibration, electricity, disease, germs, animals, etc. Then essential elements of nuisance are a wrongful act. The act resulted in the interference with the use or enjoyment of land or some right over or in connection with the land. Due to the interference, there must be damage or loss or inconvenience or annoyance caused to another. The tort of nuisance is differ from trespass, as interference in nuisance is usually indirect, unlike trespass, which is direct. Nuisance can be distinguished from negligence, as most acts of nuisance are intentional. The nuisance can be classified into two categories: the private nuisance and public nuisance. In the case of public nuisance, the injury must be suffered by the public at large. Such injury must be direct, not a mere consequential injury. The injury must be substantial in nature. Public nuisance is a crime and is defined under Section 268 of IPC. In the case of Attorney General versus POA queries, it is 1957 case. In this case, it was held that the nuisance from vibration due to the operation of quarry causing personal discomfort was sufficiently widespread to amount to a public nuisance. Then private nuisance. The private nuisance concerns act that interfere with the individual's private rights. According to Winfield and Jolofis, the private nuisance may be described as unlawful interference with a person's use or enjoyment of land or some right over or in connection with it. For an actionable claim, the interference must be unreasonable. The harm caused must be significant and of a kind that would affect an average person or property. The case law in Rose vs. Miles in 1815 case. In this case, the defendant has stationed his boat in a narrow stream of a river. Due to this obstruction, the plaintiff could not take his boat to the ferry and that to spend more money on loading and unloading of goods through land. It was held that the plaintiff is entitled to compensation because he had suffered damage. There are various defenses under nuisance. First one, grant. When the defendant had right under the terms of a contract to do an act of nuisance, no action can be brought against him. Then prescription, it applies where it can be shown that the nuisance was actionable for more than 20 years to the actual claimant. Then third one, the statutory authority. Whereas statute orders or something to be done and it is inevitably create nuisance. Inevitable accident, where a negligence is essential to liability. The ignorance of the state of affairs. Defense except failure to use due diligence. The contributory negligence may be a defense. The act of trespass, nuisance by servant, it is a weak defense. Then, in the case of Wagon versus Taffwell Railway, the defendant company had statutory authority to use locomotive engine. A fire was caused by an escape of spark. It was proved that the engines were constructed with all due care and skill, and that it was impossible to prevent the escape of sparks, so that defendant's company was not liable. The remedies for nuisance are injunction. An injunction is a judicial order of restraining a person from doing and continuing an act which might be threatening or invading the legal rights of another. It may be in the form of temporary injunction, which is granted to for a limited period of time, which may get reversed or confirmed. It is confirmed, then it takes the form of a permanent injunction. Then in Ushaban Navichandra Trivedi versus Bhagyalakshmi Chitra Mandal, its ending is AR 1978. In this case, the plaintiff had sued the defendant for a permanent injunction to restrain the defendant from showing a movie named Jai Sandoshi Mar. It was said the plaintiff that the contents of the movie significantly hurt the religion sentiments of the people belonging to Hindu religion. And the court held that the hurt of religious sentiments was not an actionable wrong. Then another remedy is damages. The damages may be offered in terms of compensation to the aggrieved party. This could be nominal damages. The damages to be paid to the aggrieved party is decided by the statute, and the purpose of the damage is not just compensating the individual who has suffered, but also making the defendant realize his mistake and deter him from repeating the same wrong done by him. There are many types of damages, namely aggravated damages, nominal damages, special damages. The abatement, it involves self-help and allows claimant to take steps to end the nuisance. Where the claimant has to enter the defendant's land for this purpose, a notice must be given. Let we discuss about the previous year questions. Which of the following is true in relation to the nuisance? An action for nuisance is actionable per se, and no special damage need to be proved. It can be committed through the medium of intangible objects. It is direct interference with the possession of plaintiff. There is no interference with the plaintiff's use or enjoyment of land. The answer is B. Then which of the following tort is not related to nuisance based on the physical discomfort or interference with another's health and safety? The obstruction of light, injury to property, noise pollution, pollution of water and air. Answer B. Then public nuisance is an offence under which law? The civil law, criminal law, patent law, human rights law. Answer B. To become a nuisance, the interference should be dash. First one, unreasonable and cliche, over the top, disturbing. The answer is A. Which of the following statement is true? Nuisance can cause injury to property. Nuisance can cause injury to comfort. Any interference can be considered as nuisance. Option A 1 and 2. Option B 2 and 3. Option C 1 and 3. Option D 1, 2 and 3. Answer A. The next is defamation. The defamation, as per Black's law dictionary, defamation means the offense of injuring a person's character, fame, or reputation by false and malicious statements. Winfield defined that the defamation as a publication of statement which tends to lower a person's reputation in the estimation of the right thinking members of the society, or that which tend to make them avoid that person. The law relating to defamation is a reasonable restriction of the fundamental rights of freedom of speech and expression conferred by the Article 19, Clause 1A of our Constitution, and is saved by the Clause 2 of Article 19. The elements of defamations are a defamatory statement that refers to the claimant, that is communicated to the at least one person other than the claimant. The communication to the plaintiff himself is not a defamation. There are two types of defamation: libel and slander. In the case of libel, the libel is a representation made in some permanent form. It is addressed to the eye. A defamatory statement in writing or printing is considered as libel. In the case of D.P. Chowdhury versus Manjulata, in this case, the defendant published a false information in the newspaper negligently with utter irresponsibility and maliciously intention about the plaintiff. The court held that the defamatory words are actionable per se, and in such case, the general damage will be presumed. In the case of slander, slander is a defamation by spoken words. Slander is addressed to the ear, but a defamatory statement by a deaf and dumb person by signs may be considered as libel. In England, slanderous words are not generally actionable, without proof or special damage. An exception to imputing the unchastity of a woman, no need to prove any special damage. This rule is not followed in India. Under Section 499 of IPC, slander is also a criminal offence in India. In Yusuf versus MGM Picture Limited, in this case, in a film, the Russian princess was shown in an uncultured form and showed to be raped and killed. This made an evil reputation to the plaintiff. The princess filed a case against the filmmakers. The question before the court was whether it amounts to slander or libel. The court held that the cinema is of permanent nature and therefore this amount to libel. There are the defense and under defamations are justification of truth, fair comment, and privilege. The justification of truth. The fundamental rule of defamational law is that truth is an absolute defense. If a defamatory statement is true, the plaintiff cannot claim damages. Therefore, if the alleged claim is true, then the publisher cannot be sued for libel or slander. In Lowen versus Daily Telegraph in 1943 case, the plaintiff was suspected to having committed an offence. A defamatory statement is made in this regard by the defendant. In this case, the defendant were allowed to plead justification by truth. In next one, the fair comment. It must be a comment that is an expression of opinion rather than an assertion of fact. The comment must be fair, and the matter commented upon must be of public interest. In South Indian Railway Company versus Ramakrishna, in this case, the ticket checker of railway was asking for the identity proof and other documents. He was doing his part of his duty, so it is not a defamatory. In the then other another one is privilege. The statement made on certain occasions are privilege. There are two types of privileges: absolute privilege and qualified privilege. Under absolute privilege, in the case of certain statements, even if such a statement is false and malicious, we cannot file a case in defamation. Such privileges are called absolute privilege. They are certain statements made in Parliament, certain report and papers of proceedings published under the order of Parliament and state legislature, and judicial proceedings. Then qualified privileges are the fair and accurate report of any proceedings in legislature, fair and accurate report of any proceedings in an international court, fair and accurate report of any proceedings in international organization, fair and accurate report of any proceedings in before a court of law, fair and accurate report of any proceedings by a public inquiry office. In T.J. Ponnam versus M.C. Varghese, in this case, the court held that the letter sent by a husband to his wife, which contains the defamatory about the father-in-law, it does not a case of defamation. Then the innuendo is the one type of defamation. Sometimes the meaning of a statement will contain inner meanings, which amounts to defamation. In Trolley versus Five and Sons Limited, 1931 case, a leading golf player picturized in a advertisement of a chocolate company. The picture of the players was shown the chocolate in the pocket. The plaintiff filed a case claiming that it will create an impression among the public that he had taken money from the company. The court held that the publication is an innuendo. Then we discuss about the previous year questions. Which of the following is not true about the slander from a form of defamation? The statement is made in some transient form. It is B. It is addressed to ear. Slander is always a criminal offence. It is not actionable in absence of proof of actual damage. Answer is C. Um, then the assertion A, making a statement of fact on matters of public interest is a defense of an action for defamation. The reason are if a defendant is a newspaper publishes as a statement of fact making serious allegations of dishonestly against the plaintiff and subsequently could not prove the truth, the plea of fair comment shall fail as based on untrue facts. The codes are the both A and R are true and R is the correct explanation of A. The option B is that both A and R are true, but R is not the correct explanation of A. Option C is that A is the true and R is false. Option D, A is false but R is true. Answer is D. Which of the following pair is correctly matched? Defamation published in permanent form. That is permanent form slander. Level is recognized as offence, England. Truth of defamatory matter is no defense in civil law. Action lies for defamatory statement, absolute privilege. Answer is B. Then dash to the plaintiff is not enough in case of defamation. Option A, communication. Option B, forcing. Option C, leaving. None of this. Option A is correct. Then which is crime according to English law? Libel, slander, both A and B. None of these. The answer is A.
അങ്ങനെ നോക്കുമ്പോൾ നമുക്ക് ഇത് മനസ്സിലാവും. See, 80 Article 80 is what about the composition of the council of composition of the council?